Let's continue our review of the exciting fight between the European Union and the ICSID arbitration and, international arbitration in general. As you might remember, there is a judgment of the European Court of Justice, Achmea versus Slovakia, where the European Court of Justice has made a declaration that the bilateral investment treaties between the member states of the European Union shall be denounced, like all bilateral investment treaties among all the members of the European Union are denounced from the day when a particular country became a candidate for the accession to the European Union, from the day when this country signed the Europe Treaty. And of course, international investors do not agree with this. They still require fair and equitable treatment that is guaranteed to them under the bilateral investment treaties. They still want to be treated fairly and equitably. They still want their rights to be protected. So what has happened? What is new in the case UT versus Hungary? The arbitration tribunal set up under the rules of the ICSID in this case has developed a new kind of argumentation. So the Achmea case was based on a bilateral treaty between Netherlands and Slovakia. And the European Court of Justice makes an argument that this treaty is not valid anymore because it is bilateral, because it was signed between two countries. And then those parties to the dispute, the Dutch company Achmea and Slovakia, have chosen to continue arbitration under the German rules. In other words, they have agreed that the German courts would issue the execution judgments, the execution order. So the argument of the arbitration tribunal in UT versus Hungary is that perhaps the bilateral investment treaty itself is a bilateral treaty, but the tribunal itself proceeds under the ICSID convention. So no national law is applicable in this case. Everything is governed by an international treaty, which is convention, which is in turn a multilateral investment treaty, the ICSID convention itself. It is a kind of speculation because I am sure that the European Court of Justice would not accept this kind of argumentation. However, this is a ground to the arbitration tribunal for declaring the Achmea judgment non-applicable. And then we have another set of argumentation that I have voiced in my previous videos. So the arbitration tribunal simply says that Hungary has never denounced nor the BAT with France, neither the ICSID convention. And even if those treaties were denounced, they could not be denounced retrospectively. So still, UT has their rights, their right to fair and equitable treaty. And finally, even if the BAT is denounced, which certain European authorities claim to be done implicitly, in an implicit manner and retrospectively, then still, under the very prima facie terms of the BAT between France and Hungary, the BAT is still applicable for the next 20 years, so until 2024. This is how this tribunal deals with the Achmea problem. As I have previously explained in my videos, in this fight I preview that the European Union will not succeed, that the European Union will not get its position, won before other foreign courts.